The Mid-Atlantic ADA Center is a member of the ADA National Network, which includes 10 regional centers which provide guidance, training, and materials on the Americans with Disabilities Act. You can contact your regional center by a toll-free number 800-949-4232 or visit adata.org. Slide 9. Without further ado, I am going to turn things over to our featured speaker for the day, Lauren Jackson. Welcome, Lauren.
Thank you, Nancy, and a huge thank you to the Mid-Atlantic ADA Center for hosting today. So again, thank you everyone also for tuning in today. I am an investigator with the Baltimore City Office of Equity and Civil Rights. So I investigate complaints of housing discrimination. So our office also investigates complaints in employment, public accommodations, education, health and welfare services. So I'm also familiar with the ADA, and we know all of the great work that the Mid-Atlantic ADA Center does. But today, we're going to talk mostly about the Fair Housing Act. So another very important civil rights law that we have, because obviously a lot of questions pertaining to persons with disabilities and accessibilities comes up about private housing. And that's really where the Fair Housing Act comes into play. So moving on to slide 10, this is just a little bit about our office. So again, we're the local city government here in Baltimore. So many of you I know are tuning in from all over the country. Again, one of the bonuses of the virtual world is that we get to reach so many people. So many of you probably have a local agency just like us who investigates housing discrimination. So it's something for you all to look into. They might be a nonprofit, they might be your local government, they might be your state government, but they're out there. But we're here in Baltimore City, and our mission is simply to carry out activities to eliminate inequity, inequality, and discrimination. And we know that accessibility for persons with disabilities in housing is a huge part of that. So on slide 11, the agenda today is really quite basic. We're just going to go over some of the frequently asked questions when it comes to housing discrimination and when it comes to accessibility in housing. Finally, we'll talk about how to file a fair housing complaint, and we'll do a bit of a Q&A at the end. So if anyone has any questions, you'll definitely have the opportunity to ask them then. So I'll also say that throughout today's presentation, if you have questions and would like to put them in the chat, I'll keep an eye on it. We'll again have an opportunity for questions at the end, so absolutely I'll be answering questions then, but as they come up, if you have them, I will try to do my best to address them. So jumping in, slide 12, again, just a little intro here, 10 frequently asked questions. So question 1, again, these are questions that were shared with us by the Mid-Atlantic ADA Center, and I have to say they mirror exactly the questions we get as a local agency here in Baltimore, and I think they'll most likely mirror all of the questions that you all have across the country. So our first question, how do I get an accessible parking spot in my apartment development? There are only a couple available for everyone with accessible tags. So the answer to this is to make a reasonable accommodation request. And simply a reasonable accommodation under the Fair Housing Act is just a change, exception, or adjustment to a rule, policy, practice, or service. So refusing to provide a reasonable accommodation can be considered housing discrimination. So what's required when a person makes a request? And again, these answers are meant to be broad. So I know we might have an audience here today where some of you are housing providers, some of you are advocates, some of you are tenants. So this is really just meant to be broad answers. But again, if you have any specific questions, feel free to ask. So what's required when you make a question or when you make a reasonable request for an accommodation? So it's simply required that the request was made to the housing provider by or for a person with a disability. So the request can also be made by, an advocate for the person with a disability, a family member, or the person themselves. And then it's required that the request was supported by reliable disability information. So the housing provider may request such information if the disability and the disability-related need for the parking space were not apparent. So if you have a mobility impairment and use a wheelchair, and the entrance to your apartment is very far from where the accessible parking spots are, that would be an obvious disability. There's an obvious connection between this reasonable accommodation for a parking space and your disability. So the housing provider in that case might not need that additional information. But if it's not obvious, then a housing provider might ask for this information. So again, this is a bit what I just said here on slide 16. So if you have difficulty with mobility due to your disability and the only accessible parking spot is 100 yards from your front door and that distance is too far, then that housing provider might not need to ask you about that information. However, if it's not apparent and they do need to ask disability-related information, they do not need a specific diagnosis or medical history. So a housing provider should never be requesting detailed medical history when you're requesting a reasonable accommodation. So I do see a question in the chat that I'll try to answer quickly. If the parking spaces are assigned to each unit and all of the existing accessible parking spaces are taken, where do you find the requested accessible parking space? Absolutely, that's a wonderful question. So in that case, and something that I should prime this with, is that the reasonable accommodation and modification, as we'll talk about later, that process should always be interactive. So perhaps there's another community member who might be able to switch the assigned spaces. Again, that's a conversation that the housing provider and the tenant should be having to try and come to that solution. So perhaps it ends up close or ends up exactly in front of the unit. Again, it's really just going to be an interactive process. All right. So when can you be denied a reasonable accommodation or modification? So in this specific case, when we're talking about parking spaces, you could only be denied this reasonable accommodation when providing them would be an undue financial and administrative burden or a fundamental alteration of the program. So again, this changes for every housing provider depending on their financial situation and depending on other characteristics about the complex. So again, not only should this be an interactive process, it's that it's a case-by-case basis as well. So I do see a question that's come up in the chat about this exact thing, about undue financial or administrative burdens. So since most housing parking lots would have to be reconfigured to add an accessible parking space with an access aisle, how is it determined what's a reasonable request and what's not? The problem is that they are always arguing that it is an undue burden to lose parking spaces to add accessible parking. So absolutely, again, that's a great question, and it really is going to come down on if it's an undue financial or administrative burden in this case. And again, this is a case-by-case kind of basis depending on the exact situation. So for this example, we take into consideration how many parking spots there are, how many parking spots they would be losing, what the financial and administrative burden of providing this accessible parking would be. So again, if you're being denied this reasonable accommodation of an accessible parking spot, you could file a complaint of fair housing, a complaint of housing discrimination, I should say. And then you'd have a housing, wherever you're at, an investigator, whether it's your local government, the state government, or the US Department of Housing and Urban Development, who would investigate your case, and they would get the documents necessary to show whether or not it would be an undue financial or administrative burden on that housing provider. So who pays for reasonable accommodations? The cost of reasonable accommodations typically falls on the housing provider. So in this case, the housing provider, if they have to pay for signage, if they have to pay for a curb cut for this accessible cost or repainting of the lot, those costs would fall on the housing provider. All right, moving on to question 2 on slide 19. My condo association will not allow us to add a ramp to the front of our home because they say it won't look good. Can they have this restriction? On slide 20, our answer. No, a condo association cannot prevent you from installing a ramp. Refusing to allow a tenant to install a reasonable modification is considered housing discrimination. So in this case, a ramp or any kind of structural change to a unit is considered a reasonable modification. So slide 21. To clarify a little bit more about the modification process. So again, a reasonable modification is just any kind of structural change to a unit that would allow for more accessibility for a person to enjoy their dwelling or access their dwelling. But when it comes to those structural changes, a condo association could require certain aesthetics for your ramp. So this example that I use on slide 21, if they require a brick ramp to match the aesthetics, but you found a metal ramp that was half the cost. So your metal ramp cost $1,000, their brick ramp cost $2,000, they would be expected to pay that additional $1,000. If they are not willing to do that, they cannot disallow you from installing that metal ramp. You still have to be able to make that reasonable modification to your unit. Speaking on reasonable modifications, a condo association may require that you return it to its original condition if it's reasonable to do so. This, however, under HUD's joint statement on reasonable modifications, only applies to the interior of the unit. So if, for example, you made a structural change where you installed a roll-in shower or you removed lower countertops, that condo association might require that you return the unit to its original condition. If you did something like widen doorways or something that would not affect it for the next tenant, then it would be considered unreasonable to make those changes. All right, moving on to slide 23, question 3.1. So this is question 3.1 because there are quite a few sections to this, specifically regarding assistance animals. So this is a hot topic in the world of fair housing, and I am going to try and provide as much clarity as I can on this topic. So question 3.1, we're a landlord and we have many tenants asked to have emotional support animals. Can we really not charge fees? And the answer on slide 24, no, you cannot charge fees for assistance animals. So assistance animals is the term that the U.S. Department of Housing and Urban Development is using. So assistance animals are not pets. The way they are defined are animals that do work, perform tasks, assist, and or provide therapeutic emotional support for individuals with disabilities. So there are two types of assistance animals. One, service animals. So under the ADA, we have our definition of service animals. And then two, other animals that do work, perform tasks, provide assistance, and or therapeutic emotional support for individuals with disabilities. So again, that's the difference here under the Fair Housing Act. They do not define service animals in the same way. This is the term that HUD is using at this point as assistance animals. So question 3.2. We're a landlord and we have many tenants asked to have emotional support animals. How many can they have at one time that are emotional support? So the answer on slide 26, individuals can have as many assistance animals as reasonably supported by information provided regarding the accommodation request. So if a person requests an accommodation to a no pets policy for an assistance animal, and then they can show that they need more than one animal using reliable information from a service provider, whether that be a medical professional, a licensed social worker, a licensed counselor, therapist, that can show that they need multiple support animals, then that has to be as many as you allow. So I've seen some questions, and I hope this answered how many service animals can be in one unit. Again, it's dictated by that reliable disability information provided by a medical provider or a licensed social worker, licensed therapist. As long as there's a nexus between a person's disability and the need for multiple support animals that can be proven with reliable information, then that is how many have to be allowed. So there's no specific number. And then again, when it comes to what kind of service animal, there is no definition under HUD's guidelines under the Fair Housing Act on what kind of animal it can be. So it could be, as you see, a peacock, a bird, it could be a dog, a cat, really any service animal, a fish, it's all included. HUD does not define what kind of animals are assistance animals. And again, I see a question about if the animals have to be certified or not. So the animals do not have to be certified or trained in any way under the Fair Housing Act. All right, question 3.3. So still on the topic of assistance animals on slide 27. We're a landlord and we have many tenants asked to have emotional support animals. Can we ask for documentation? So the answer on slide 28, yes. For non-obvious disabilities, you can ask for documentation. So the documentation you can ask for is information that reasonably supports that the person seeking the accommodation has a disability. Again, such as a determination from a government agency, receipt of disability benefits or services, or information confirming a disability from a healthcare professional. Again, this can include licensed social workers, therapists, counselors, medical providers. And so I see the question again in the chat about the difference between service animals and emotional support animals. So again, a service animal is defined under the ADA. I believe this is typically only dogs and miniature horses. And the ADA folks might have to correct me there, that are trained specifically for a task. In the case of assistance animals or emotional support animals, which is sometimes the term that is used, they do not have to be specifically trained to do a task, and they do not have to be a certain kind of animal. So they can be really any kind of animal. So are there any limits, another question that I'm pulling from the chat, on assistance animals related to health or safety concerns? So absolutely, when it comes to any reasonable accommodation or modification, safety is concerned. So if the animal poses a threat to people, to the individual themselves or others in the complex, that can't be mitigated with another reasonable accommodation, then in that case you could deny it. The landlord could not limit the size and weight of the animal. Again, if it poses a safety concern, then potentially they could deny this reasonable accommodation. So reasonably supporting information often consists of information from a licensed healthcare professional, general to the condition, but specific as to the individual with a disability and the assistance or therapeutic emotional support provided by the animal. So again, hopefully this answers the question that just came up in the chat. So again, you can ask for this supporting information from a licensed healthcare professional, licensed therapist, social worker, that shows a person's disability and the connection to the emotional support animal, and how that emotional support or assistance animal, again in the case of HUD, provides some kind of assistance or therapeutic emotional support to a person with a disability. Question 3.4 on slide 30. We're a landlord and we have many tenants asked to have emotional support animals. What if we advertise specifically that we are no pet, and the expectation of the other tenants is that they will not have to encounter dogs on the property? Do we still have to allow them? So the answer on slide 31, yes, you still have to allow assistance animals. So again, obviously this is a hot topic and there are several questions coming up in the chat. And I think the best answer for folks who have more questions about this is to refer to HUD's assessing a person's request to have an animal as a reasonable accommodation under the Fair Housing Act. So I've provided the link here. Again, you could just, type that into Google or whatever search engine you're using. And this walks you through all of these questions. This guidance is great, and I think we'll answer all of the questions that have come up in the chat about assistance animals and allowing them. So again, just another question that's been reiterated is if the animal, the assistance animal, is a threat to the health or safety of others, and that can't be mitigated through another reasonable accommodation, in that case, you could deny that reasonable accommodation. Again, just for the sake of time, I'm going to continue, but I highly recommend referring to this guidance from HUD, and I'm happy to come back to questions at the end as well. Moving on to slide 32, question 4. I was in a recent accident and will have to be using a wheelchair for at least a year, possibly more. The units in this complex are completely inaccessible for me now. Can they still charge to break the lease? On slide 33, the answer, it would be considered a reasonable accommodation to allow you to break the lease. However, this is a discussion you will have with your housing provider where other solutions may also be discussed, such as moving into an accessible unit. So again, this just reiterates the fact that the reasonable accommodation and modification process should be an interactive discussion. So most of the time, a person with a disability is going to be the expert on their necessary reasonable accommodation and modification. But a housing provider can also bring up, other potential options. The person with a disability always, can deny those if they do not work for them. So if moving to another accessible unit might not work because you're planning to move in with a care provider, a family member, someone somewhere else, then they would have to allow you that reasonable accommodation to allow you to break that lease. But again, this can be an interactive discussion. All right, slide 34, question 5. The elevator keeps breaking down in our building. What do we do? So on slide 35, the answer, it is expected that a housing provider would address this in a reasonable amount of time. What amount of time is reasonable is not defined under the Fair Housing Act. But in a situation like this that could strand you out of your apartment or into your apartment, this is obviously a repair that should be addressed immediately. So on slide 36, if the repair is not addressed immediately, you can file a fair housing complaint. So again, anywhere in the US, you can file with the US Department of Housing and Urban Development because disability is one of our 7 federally protected classes. You could also file with any of your local agencies. So if you're here in Baltimore City, you can file with the Baltimore City Office of Equity and Civil Rights. We also have the Maryland Commission on Civil Rights, and I'm sure if you're in another state, you have a state agency as well. And there are also several nonprofit housing centers that may test for compliance. So often these are nonprofits. So if you have someone come out who's able to do essentially secret shopping. So again, that might depend on the area you're in, if there's a testing program through a nonprofit, but it's something to look into. Moving on to slide 37, question 6. There is no ramp into the building. Shouldn't there be a ramp for all buildings? So on 38, answer. So all multifamily dwellings, so that's any dwelling with 4 or more units, built for first occupancy after March 13th of 1991 should have an accessible entrance. So prior to this date is essentially when the Fair Housing Design and Construction Guidelines went into use. Anything prior to this date was not required to have accessible entrances. Anything after this date, though, again, built for first occupancy after March 13th of 1991, should follow the Fair Housing Act's required 7 basic design and construction guidelines. However, a tenant can always request that a ramp be added as a reasonable modification. So on slide 40, all housing that receives federal funding should also be accessible under Section 504 of the Rehabilitation Act of 1973. So if you're in public housing, project-based housing, all of that housing should be accessible or should be made accessible at the cost of the housing provider. So moving on to slide 41, question 7. Why does it seem that there's so little accessible housing? Isn't it a legal requirement? Doesn't all housing have to be improved over time? So the answer on slide 42, the basic design and construction guidelines only apply to multifamily dwellings, 4 units or more. So this is why we'll see single family housing that's built that's not accessible, standalone townhouses. These kind of things are not required to be accessible under the Fair Housing Act. So additionally, the question involved, don't they all have to be improved over time? At this time, the Fair Housing Act design and construction guidelines do not require that during alterations or renovations, buildings be made compliant if they were built for first occupancy prior to March 13th of 1991. And then again on slide 43, just to reiterate, any housing that receives federal funding should be accessible under Section 504 of the Rehabilitation Act. All right, moving on to question 8. So we do just have 10 questions here, so I will definitely be able to answer any questions about emotional support animals that I have seen come up in the chat again, or other questions at the end. So we'll definitely revisit that topic. On slide 44, moving on to question 8, we need to add safety rails in our bathroom. Who pays for this? Or similarly, this question, we have a list of items that we need for our unit to be accessible. Who's responsible for this? So the answer on slide 45, the tenant pays for the cost of any modifications. So if you're installing a ramp, if you're installing grab bars, any structural change, again, is what's considered a reasonable modification under the Fair Housing Act, comes at the cost of the tenant. The only exception is again, if you are in housing that receives federal funding. So in that case, again, under Section 504 of the Rehabilitation Act, another federal law separate from the Fair Housing Act, then the cost of the modifications is on the housing provider. All right, moving on to question 9. There are no curb cuts in the development from the parking lot to the sidewalk. What do we do? So slide 47, the answer, you can request that curb cuts be installed as a reasonable modification. Again, this cost, the cost of structural changes, will be on the tenant. However, since others will use them because these curb cuts are in a public space, the housing provider will be expected to pay for any maintenance or upkeep of this modification. And again, just to reiterate, any housing that receives federal funding and falls under Section 504 of the Rehabilitation Act will be expected to cover the cost of any curb cuts. On slide 49, the only exception to this when the question of curb cuts comes up is that, going back to question 1, in the case that you need a reasonable accommodation for an assigned parking space, then the cost of that reasonable accommodation will fall on the housing provider. So again, things like painting lines, repainting parking space lines, installing an accessible parking sign, or adding a curb cut, then that cost will fall on the housing provider as long as they cannot prove that it would cause an undue financial or administrative burden. Again, slide 50, reiterating what I just said, so that again, a housing provider can only refuse a reasonable accommodation request if it would be shown to cause an undue financial or administrative burden. Okay, so I see a great question in the chat. Does a person have the right to choose who puts the curb cut in? So yes, when it comes to reasonable modifications, so if the tenant is, paying for these modifications, if they're paying for the person who's installing grab bars or adding their ramp, then they have the right to choose who makes those reasonable modifications. The only things that a housing provider can require is a description of the proposed modification, making sure that they have the correct building permits and that it's done in a workmanlike manner. So the housing provider cannot condition the contractor that they use, but they can ask that it be done in a workmanlike manner with the correct building permits. So definitely there's a question about public right-of-way. Again, to have all of the correct, not just building permits, but right-of-way permits, any right of entry permits, anything that's necessary by the municipality, then that person would have to have as well. Okay, so I do see another question. Can you please address automatic door arms for apartment complex entry doors? I don't believe this is required, but could this be a reasonable accommodation at the cost of the complex since it's a benefit for all tenants? So again, for this one, because it's a modification, it is likely going to be on the cost of the tenant. However, the upkeep would most likely be, or would definitely be, on the housing provider. So any upkeep associated with the automatic entry doors. One of the 7 accessible designs under the Fair Housing Act design guidelines is an accessible entrance on an accessible route. So if it was built for first occupancy after March 13th of 1991, it should have an accessible entrance. I'd have to go back and look at it because I'm having a bit of a mind blank here. If that requires automatic doors or not, I do not believe it does. But the entrance must be accessible on an accessible route under the Fair Housing Act's design guidelines, which again only apply to properties built for first occupancy after March 13th of 1991. All right, so question 10, our final question here, and then we can definitely just roll through some in the chat. So there is no pool lift at our community pool. Isn't this required by law? So really at your community pool, I can't speak to, but thinking about your community pool, if it is part of your housing complex, the Fair Housing Act design and construction guidelines require that the area around the pool be accessible, but there is no set requirement for an access into the pool itself. So there's no requirement for a pool lift. However, you could request a pool lift to be installed as a reasonable modification. So again, this is a structural change, installing the lift into the pool. That cost is going to fall on the tenant, but because it's something that's going to be used by other tenants potentially and other people in the complex, that housing provider is going to pay for the maintenance and the upkeep. So I'm just going to quickly go through the chat and try and glean a few questions that might not have gotten answered at this point before we talk about filing a fair housing complaint. So here's a question. At what point, if at all, can a tenant proceed with a modification to a common area without landlord approval? So in the case of reasonable modifications, you always need the approval of a housing provider. If a housing provider continues to refuse to respond to requests for installation or continues to delay it or doesn't answer questions, then at this point you could file a fair housing complaint, because refusing to provide a reasonable modification or accommodation is considered housing discrimination. So absolutely you can get in touch with your local agencies or again with the U.S. Department of Housing and Urban Development to file a complaint. So I hope that answered that question.
Lauren?
Yes.
I have a question that we received here in the center that you might be able to respond to. The individual says, I requested from my landlord an assigned parking space and provided documentation. And the landlord installed a sign, but it's just a standard accessible parking sign. So anyone with a permit, including a visitor to the complex, could park there. The landlord said he can't reserve the space only for me. If it's a reasonable accommodation, shouldn't it be designated somehow for my use?
Yes, that would be correct. So in that case, if the tenant requested that spot for themselves as a reasonable accommodation, then that spot should be theirs to use. Again, this question comes up because housing providers will sometimes say, look, we have other accessible parking spots that are available in the lot. However, if it's not close to your unit, or those are a first come, first serve basis, that's not going to necessarily help if you have a disability. So absolutely, when you request that reasonable accommodation for that parking spot for yourself, then that space should be designated as your own, because again, in the first come, first serve kind of basis, that parking spot might not be serving your needs if you get home and someone else is parked in that spot. So that would absolutely be, again, a conversation to revisit with that housing provider to let them know that your reasonable accommodation needs a specific parking space for yourself, not just for the complex overall.
We did have one other question,
Yes.
Lauren, you mentioned about landlords being able to require that tenants return modifications to their original state. My landlord wants me to put money in an account to replace the tub from a roll-in shower. Can they do that?
So that is definitely where the Fair Housing Act gets a bit murky. So sometimes housing providers are allowed to have you put money into escrow accounts for a modification. Typically, they have to have some evidence that it is financially a smart decision for them to do this. So if it's based on credit score or previous references or something like that that makes them somewhat concerned about your finances, then they potentially might have a reason to ask you to put it in an escrow account. However, if there's none of that evidence, then that's not really going to apply. And with the escrow account, you can only be required to put in exactly how much returning that modification would cost. And if your housing provider chooses not to make that change, then all of that money has to go back to that tenant. So if you put money into escrow and they leave that roll-in shower after you leave the apartment, any money you set aside into escrow has to be returned to you. So again, that's really a case-by-case basis. It goes, again, a bit into it in HUD and the DOJ's joint statement on reasonable modifications if you want a little more info. But again, that's kind of the murky area. So it is allowed, but again, it really depends on the specific circumstances.
We are really getting some questions about parking here. We have a couple more that have come in to us. One is, I have a disability that's not obvious. I want to use one of the disability parking spaces in my apartment building's garage. I showed them my disability parking placard, but they want me to fill out a form with my doctor's input. Is this necessary? Shouldn't the placard be enough?
Yes, in this case, depending on who the placard's coming from, assuming that that is an officially issued way to show that you have a disability, in that case, that should likely be enough. So again, other things that would show that you have a disability, if you receive any kind of financial assistance from the government, SSI, SSDI, all of those things also go to show that you are a person with a disability. So in that case, I think that would likely be enough information. If you already have the placard for accessible parking and you want to use their spaces that they already have assigned for other individuals with disabilities, then absolutely, I think that they would have to allow that.
I think we have a couple of other parking. Now, parking, we've switched our hot topic to parking here. So let's see if I can get to the next one here. Now, here's something sort of the flip side here. This person says, I need to use the accessible parking space near my house. Someone else is currently assigned the spot, but she lets other people who are not disabled use it. What can I do about that? The city doesn't want to add another spot in the same area. That one's loaded, isn't it?
That is loaded. I would say that the city, if this is in your neighborhood near your house and the city comes out and provides accessible parking spaces designated in front of your home or near your home, they would have to provide that accessible parking spot to you. They can't really rely on there's already one nearby if it's designated for someone else. So I think that's the basic answer there. Your neighbor sharing their accessible parking spot with people who don't need it, I can't really speak to. But I can say that the city, if you need an accessible parking spot, it would not be a reason to deny you because there's already another close by that's assigned to someone else.
Okay, thank you. You're giving us so much good information here today. We do have one question that came into us just to clarify. To get an assigned parking space, the individual would need to establish that the reserved space is necessary and not simply a preference. Is that correct?
Correct.
Okay, I think we have one more about parking. No, I think maybe we've gotten through all of the parking questions here. We do have one other question that came in directly. I live in a building with a lot of elderly people. There need to be railings around the property for all of us to get around safely, but the property manager doesn't seem to think they need to install these railings. I was told that the building doesn't comply with the Fair Housing Act construction and design standards. Not sure if you can parse that one out.
Sure. So again, if your building does not apply the Fair Housing Act's design and construction guidelines and was built for first occupancy after March 13th of 1991, then you can reach out to your local fair housing agency because you might have grounds for a complaint. So all of those housing providers that were built, 4 or more units after March 13th of 1991 are expected to follow the Fair Housing Act's basic construction guidelines. However, railings throughout are not necessarily one of them. So it is required that there be an accessible route, into and through units and through common spaces, but I do not think that necessarily requires railings. That is more of a question of width, especially related to folks who use wheelchairs. So that's really what kind of accessibility there is in those kind of public spaces. Again, if these railings are needed, the railings specifically, I do not think are going to fall under the Fair Housing Act's design guidelines. So that is going to be considered a reasonable modification. So I hope that answers that question.
Thank you. I think you've answered quite a few questions here. And so I'm gonna let you get back to your material or to other questions that you can see coming in there.
Yes, absolutely. So I'll go through a few in the chat, and thank you to Jenny in the chat for pointing out, again, if the property receives federal funding, again, they will fall under Section 504 of the Rehabilitation Act of 1973, and those modifications are going to fall at the cost of the housing provider in those cases. So to go back up to answer another question, so just to clarify, if a reasonable accommodation request involves a structural modification, so ramp, pool lift, automatic doors, this cost always falls on the tenant. If the accommodation is not structural, this responsibility falls on the landlord. So yes, that's very close to being correct. Again, the only exception is going to be what we just talked about. So if the building receives federal financial funding in some way, then the cost of structural modifications is going to be on the housing provider. So again, project-based housing that receives federal financial funding, the cost for those structural changes, so reasonable modifications, is going to fall on the housing provider. In most other cases, in any kind of private housing, the cost of a reasonable modification, so the cost of that structural change, is going to fall on the tenant. The cost of a reasonable accommodation, so again, an accommodation is just any exception to a rule, policy, or practice, is going to fall on the landlord. So the main one we talked about today was the accessible parking spot, but other common accommodations include, someone who might need a lease in a larger print font. So then the housing provider would make an exception to their practice of providing a standard size font on their lease and print out a larger print font for a person with a disability. And that cost of that accommodation will be fairly small, and it will be on the housing provider. So that's just another example of an accommodation. Similarly, if a person has a disability and they do not like to leave their unit, and the housing provider requires that tenants turn in their rent in person at the rental office, it would be a reasonable accommodation to make an exception to that rule to allow someone else to turn in that rent payment for that tenant. So those are just some more examples of reasonable accommodations. Reasonable modifications, so structural changes, are obviously very clear. Reasonable accommodations, again, are really just exceptions to rules, policies, and practices. So I see another question. So I believe, for the deaf and hard of hearing, strobe alarms in rental apartments and housing, are landlords supposed to swap out lights for a strobe? We had a situation where the landlord made them pay part of it because they asked for 3 throughout the living space. So again, I do believe that this would be a reasonable modification. They are making a structural change to their apartment by installing a different kind of alarm. So that cost is likely going to be on the tenant. Again, if they end up in the common spaces, then the housing provider will be the one paying for the maintenance and upkeep of those. So I hope that provides some clarity there. And then I see another question, can you get my email? Absolutely. So I will put my email in the chat for everyone now. Happy to answer any questions anytime. Like I said, I work here specifically in Baltimore City, but we provide outreach under the Fair Housing Act. So those rules apply all over the country. But I'm going to talk now a bit about filing a fair housing complaint, and then we can come back to any other questions at the end. So again, a lot of what we just talked about was making reasonable accommodations and modifications. So any denial or delay in providing those reasonable accommodations and modifications are grounds for filing a complaint of housing discrimination. So to file with our agency, if you're here in Baltimore City and you tuned into today's presentation, thank you. To file with our office, so the Office of Equity and Civil Rights, specifically the Community Relations Commission, which this acronym stands for, the alleged discrimination must have taken place within the past 180 days, so that's about 6 months. To file with the U.S. Department of Housing and Urban Development, the alleged discrimination must have taken place in the past year. And then to file a private lawsuit, the alleged discrimination must have taken place in the past 2 years. So again, anyone can file a private lawsuit about housing discrimination. You don't necessarily have to go through HUD or your local agency first. But again, the HUD process, you don't need an attorney. It's at no cost to you. Same with our local agencies. Same with the local nonprofits that might be in your area. So just something to consider, that these are all of the routes you can kind of go through to file complaints of housing discrimination. So cases of sexual harassment in housing and pattern and practice cases may be initiated at a later time. So we always tell folks that if you've experienced housing discrimination, even if it was past these time windows, so if it was 3 years ago, 4 years ago, it makes sense to come forward just in case someone has recently experienced the same thing. So if we find out that there's a history of a housing provider refusing to make reasonable accommodations or modifications, or evicting folks with disabilities, or any kind of pattern and practice case, then we can bring in those cases from previously, since we have a case that happened recently. So again, if you've experienced it, it's always good to put it on your local agency or HUD's radar. So here is the website on slide 56 of where you can file with our office. Again, you must be in Baltimore City, but you can visit civilrights.baltimorecity.gov/community-relations-commission/file. You can also reach us via email at crcintake@baltimorecity.gov or call us at 410-396-3143. And then on slide 57, you can file with the U.S. Department of Housing and Urban Development as well. Again, this applies to any discrimination on the basis of disability. This is a federally protected class, so any denial of reasonable accommodations or modifications for your disability can be filed with HUD. So you can visit www.hud.gov/fair_offices/fair_OPP/online-complaint. You can also call HUD to file a fair housing complaint at 1-800-669-9777. All right, so that is it in terms of how you file a complaint. Like I said, for those folks who are outside of the Baltimore region, you can always file a complaint with HUD, but you might also have a local state agency, a local city agency, or a local nonprofit. It's also important to point out that there are additional protected classes. So everywhere in the US, you're protected on race, color, national origin, religion, disability, familial status, and sex. But your local jurisdictions might have additional protections. So again, one that we have here in Maryland is source of income. So folks with disabilities who have SSI, SSDI, or use a housing choice voucher might also experience discrimination based on source of income. You might have other additional protected classes in your area, so it's always worth looking into. And complaints of fair housing, again, don't have to be just because of one protected class. You can file under multiple protected classes, and you can also file on behalf of someone. So again, if you're being discriminated against because of your association of with a person with a disability, then you can also file a fair housing complaint. So I did see one question pop up in the chat that I'll answer now. So why doesn't HUD state that emotional support animals/assistance animals, when they are a dog and service dogs, are required to align with state and local animal control laws for care, control, leash laws, cleanup, housing grounds, disturbances, and safety hazards to others in the community? When HUD states ESAs are not required to be trained, has caused and continued to cause incorrect interpretation and implementation of laws. So all good points. I think, again, if a housing provider requires that an emotional support animal follow any kind of local laws, so if they are a dog, that they have to be, licensed, vaccinated, whatever the laws are, then most likely that's going to be fine. Again, the conversation should really be interactive. So if you do have an assistance animal who's a dog who's not trained to provide, a specific service, they're not a guide dog, they're your emotional support animal, but your housing provider wants, you to be able to show that they're registered with the city or whatever the local law might be, that is most likely going to be okay. It's not going to necessarily be something that impacts a person's ability to have an emotional support animal to have those questions. And again, when it comes to safety hazards, HUD does allow, if that assistance animal is a threat to anyone else's safety or health, that reasonable accommodation can be denied. Again, you have to try and mitigate that through a reasonable accommodation first. But if that service animal does pose some threat to safety or health, they can be denied. So I will just highlight again HUD's guidance on assessing assistance animals. Really helpful. That came out in January of 2020. I highly recommend everyone read that. It really goes through all of these questions in a lot of great detail. If you still have questions, like I said, assistance animals are definitely the hot topic. But the other two main guidances that HUD has are joint statements between HUD and the Department of Justice on reasonable accommodations, and another on reasonable modifications. So those are just three great resources to look into after this if you have more questions. Also, my email's in the chat now, so if you have other questions, feel free to reach out and I am happy to answer them. Nancy, were there any other questions that came up, or did anyone have any others? Great.
Yes, we have actually a couple of questions about university housing. Okay. Dormitories and stuff and such. So perhaps you can speak to this. One question says it's an issue about a dormitory that's owned by a private company at a state university. So does that make any difference? Is that just Fair Housing Act, or does it matter that the housing is somehow associated with a state university?
So that housing is still going to fall under the Fair Housing Act. So in the case of modifications, accommodations, those rules are still going to apply to university housing for the most part. There are occasionally exceptions when it comes to occupancy rules. So that's something. So if you have someone who's providing care or other things, sometimes university housing falls under different rules. Really, it's a case-by-case basis kind of thing. But I would say for the most part, any student housing, especially if it's privately run, is going to fall under the Fair Housing Act.
Now we have another question about university housing. Would this possibly be an example of a reasonable accommodation? They've had a request for on-campus housing as an accommodation beyond the first year. And normally the school guarantees on-campus housing for the first year, but not beyond. And the request is for guaranteed housing beyond the first year.
That's a great question. So again, I think that is a reasonable accommodation request that you can make under the Fair Housing Act. If the university is able to prove that would be an undue financial or administrative burden or a fundamental alteration of their program, then perhaps they could deny it. Again, it would really depend on the financial situation of the institution. If, for example, when we're talking about the alteration of a program, if a university never provides housing, and then the request is for them to provide housing, that might be a fundamental alteration of the program. But I think in this case, since it's clear that the university does provide housing to some students, even if they're just first year, that's not necessarily a huge alteration of their program. They're already providing housing in some form. So I do think it would be a reasonable accommodation request that you could make.
Great, thank you, Lauren. As you can see, we're getting a lot of great comments about today's presentation. We did have one other question that came in related to when you were talking about filing complaints. And the question is, if someone files with a state or local level fair housing agency, is it also considered to be sort of dual filed or cross filed on the federal level or with HUD, the sort of thing that we sometimes see under the ADA? Do you know if it works that way as well with the Fair Housing Act?
So it definitely depends on the agency. So for example, our agency, the local city government, only investigates under Article 4 of the Baltimore City Code. So the state agency investigates under the state laws here as well as the federal laws. So technically, you could file with our office, who only investigates under our local laws, and then file with the state's office. But because the state also investigates under the Fair Housing Act, you couldn't then go and file with HUD. So yes, very similar to ADA. If there's a work sharing agreement. So often those are known as the Fair Housing Assistance Programs, Faps, and those are typically state government organizations. Some city governments are also Faps, and those are what have work sharing agreements with HUD, who investigate under both federal and state laws. So yes, it would be considered to kind of be dual filing if you go to both. Most likely in those circumstances, they will let you know.
Great, thank you. We do have a follow-up here, and I think actually this is one that you can see in the chat box there, referring back to some of the housing and dormitories that we were talking about a moment ago. Wouldn't housing at a place of education, like a state university, also come under the ADA?
You know, I feel like that could be a great question for the ADA network. If you all see any questions about student housing, I think, again, it definitely falls under the Fair Housing Act. And a lot of times when we see at least construction guidelines when it comes to accessible design, the ADA and the Fair Housing Act are going to be fairly similar. But in terms of reasonable accommodations and modifications, I can't say if that would fall under the ADA's reasonable accommodation policy. I think likely, you know, you could be covered by the Fair Housing Act, but if you were interested under that law, hopefully you all at the ADA network could provide a little more information.
We absolutely could. And in addition to encouraging you to call or contact Lauren, you certainly can contact us here at the Mid-Atlantic ADA Center or other regional ADA centers across the country, and we can often help you sort through and untangle the particulars of a situation, because just as Lauren has mentioned, we often see Section 504 applying to housing as well as the Fair Housing Act, and then in some cases we see the ADA overlapping there a little bit at times as well, particularly when we're talking about public housing or housing at public universities and that sort of things. I do see another question in here about fair housing enforcement. At what point do fair housing agencies regard a long-term stay facility to be covered by the Fair Housing Act, as opposed to something that's more like a hotel, where you might see people staying, weeks or a longer time? Kind of can you speak to the distinction there?
Yeah, so I'm not sure that there is an exact line that I know of, and I can definitely look into it more. We always say that the Fair Housing Act is, a floor and not a ceiling. It really relates to any housing-related transaction. So often when we think of shelters and other places of temporary residency, that those fall under the Fair Housing Act as well. With hotels, a lot of times we do see that more under things like the ADA because they're providing a good or service. But I think sometimes if you're talking about, folks spending longer times at hotels or motels, it could be a consideration under the Fair Housing Act, but I do not know what that exact timeline looks like.
I can tell you that under the ADA, the Department of Justice tends to look at a 30-day sort of point that distinguishes between, transient lodging, hotel versus housing. I don't know that it's really a hard and fast bright line, but it certainly is an indication of that distinction. And I think that also a factor is if you leave, are you coming back to the same room or unit? And you see that with shelters sometimes where, people are staying there for a long, long time, but maybe they have to leave every day and then come back at night and they might get a different room or a different bed. And that's less like a residence. So there really are a lot of, as you say, Lauren, you really have to dig into the particulars of a situation, don't you?
Yes, absolutely. Like we said, everything is really case by case when it comes to housing. No situation is exactly the same.
Yes, it really is. And again, under the ADA, when we start looking at housing, and even some of these issues that have come up here today with dormitories and other, college housing at colleges and universities, sometimes you really actually have to look at those specifics to figure out, is it covered by what law, how, what's the connection? Sometimes these, like the question we had earlier about a private company running a dormitory, you kind of have to know, is that private company really operating a state program, state university housing? Or is it really just an apartment complex on the private market that just happens to be nearby the university, and it seems to be mostly all students that live there, and it kind of looks like student housing, but it's really just a private apartment complex? Or is it really university housing? So again, just a great example of what you're saying about how sometimes you really have to look at the particulars. I don't see any other questions in here at the moment. I see some more comments about what a great and informative session we've had today. So again, folks, if you have other questions, feel free to type them in to the chat box. We do have some time left in our session. We could move on and just look at our last few slides, if you like, and go ahead and get that last minute information out to folks while they're maybe thinking of their last minute questions.
Sure.
And typing them in there.
Do you want to share the screen, Nancy, or I can go on to the next slide?
Oh, there we go. That's great. Yes, we did. We wanted to just remind folks to save the date for our annual conference this year, which is coming up in Baltimore, September 21st through the 23rd. We will again be in person this year, back to our in-person conference in Baltimore, Maryland. It's going to include a variety of sessions based around a few topical areas, including fair housing issues, ADA and Fair Housing Act, other state and local government issues, employment, corrections issues around detention and corrections, and some general sessions as well. So stay tuned for more details. We'll be opening registration very soon. Visit us online at adacon.org. This is going to be an in-person conference this year. We will not be having a virtual conference as we did last year. And I think on our next slide, we have the code word for today's session. The word of the day is equity. Equity. If you paid for a certificate of participation or credits, check the reminder email that you received about this session for instructions and follow those instructions. Please email the code, which is equity, to adatraining@transcend.org by 5 p.m. Eastern Time, close of business on May 24th, 2021, this year. And I think our final slide is just, again, a reminder of our contact information here in the Mid-Atlantic ADA Center. We do thank you so much for joining us today. Again, the toll-free number is 800-949-4232. If you are here in the Mid-Atlantic region, in Delaware, the District of Columbia, Maryland, Pennsylvania, Virginia, or West Virginia, you will get us when you dial that number. If you are outside that area, or your phone thinks it is, based on your area code, you will get a different regional office. If you need to contact us here in the Mid-Atlantic region directly, you can use our local number if you're outside our region, 301-217-0124. You can email us at adainfo@transcend, or you can visit us online at adainfo.org. So I don't see any last minute questions. Let me just double check here in the chat box, because we do have a little time left. And if we did have a question, we might be able to squeeze in another question or two. Now, here's an interesting question. Do you see many cases where disability is being treated simply as a protected class? In other words, complaints of just straight discrimination. No accommodation is requested. No modification is being requested. It's just a matter of straight bias, prejudice. They don't want the person around. Do you get complaints like that?
Yes, absolutely. So really kind of any different treatment is going to be considered housing discrimination. So if folks are being charged higher security deposits, if they're being harassed, if they're, being called names, or, obscene language is used about them, or their disability, if they're being evicted because of their disability, really any kind of treatment that you can show is different than other folks are being treated because of someone's disability is also housing discrimination. So again, you're right, we talked a lot about reasonable accommodations and modifications today, but really any kind of disparate treatment of folks with disabilities is also considered housing discrimination. So you've completely have the grounds to file a housing discrimination complaint if you're being harassed because of your disability, or treated differently in any way.
Thank you, Lauren. That's good. And that was a great question to remind us that sometimes discrimination is just, your garden variety, old-fashioned denial of opportunities, exclusion, and harassment. I'm glad you brought that up, Lauren, because we get calls about those issues as well. Sometimes people feel that they're being harassed, and when it's in their living environment, where they live, and they feel they're being harassed sometimes by neighbors, or even by their landlord. It can certainly be an emotional situation for folks. So thank you for whoever brought up that question. But seeing no further questions at this point in time, I think that we are going to give folks back about 10 minutes of their afternoon. And I hope all of you will join me in thanking Lauren for all this great information today. And we certainly thank all of you who have joined us this afternoon. Enjoy the rest of your day.